There has to be some common sense.
Yes, sir. They have the car stopped at 10th and Ranch, Michael Byler.
We still don't know who pulled the trigger. Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, 27-year veteran of the NYPD. I hope wherever you are, you're staying dry. It's been one of the wettest weekends. It seems every weekend it rains in the Northeast. Anyway, that's neither here nor there, but I did a little Coffee with Cannon show this afternoon, and I was almost ready to build an ark and start loading one of every animal in Westchester on it because I didn't think I was going to get out alive with all the rain we've been having. So, folks, the Kohberger case, there's some issues coming up, of course, and the defense is really getting involved right now with different issues that they have. They're demanding that all evidence be turned over right now. Demanding. We know that you can't always demand anything. The prosecution is playing by the rules of evidence, by the rules of the criminal procedure law, and by Idaho criminal procedure law, they're required to turn over all discovery, all evidence that they have prior to the start of the trial. That is the language in the criminal procedure law in Idaho. And we all know that the start of the trial is supposed to be October 2nd. So as long as they comply with that, they will be within the guidelines of the law, and the defense can't demand anything. They can ask for it. They could petition the judge, and certain things just recently the judge ruled on. It appears that they're going to be targeting some of the training materials that the investigators on this case were trained, certain things they were trained in. They want those records to see how qualified the investigators on this case actually are. What were they trained in? How qualified were they to take statements, collect evidence, take measurements, look at video, interpret cell phone information, specifically pinging cell towers. That's usually the expertise of those that do that. On the NYPD, I always refer to that because that's what I know. We have a unit called TARU, T-A-R-U, which stands for Technical Assistance Response Unit. And they do our cell phone work, although the detectives actually deal right with the carriers. And they get when they request the incoming and outgoing calls, when they request the cell tower information, they have to get that, but they can be assisted by this highly technical unit on the NYPD known as TARU. And they do a lot of the cell phone information, and they can be spoken to. And they can help the field detectives in interpreting the cell tower information, the cell phone information. Look, cell phones in themselves, the best arbiters of cell phones and the people that know the most about cell phones these days are your kids. I know you can't bring them to an investigation, but whenever I have a question in regards to my cell phone, you got to realize that myself and Mike Geary and Phil Grimaldi and Melanie, we weren't raised with computers. And cell phones are just mirroring really your computer. So whenever we have questions, we go to our kids and they, oh, what are you kidding me? They know exactly all about cell phones and how to do this and how to do that. In fact, when you see kids, they text with two thumbs and they're like lightning, you know. And I noticed that even when I go to my gym, kids, I refer to college kids, they can't put their damn cell phone down. You have to, you feel like telling them, hey, Johnny, leave your damn cell phone in your locker when you work out, because the only workout you're getting is your two thumbs. Are you doing fingers and toes today? Is that the body parts you're doing? Because they can't put their damn cell phone down. But as a result, they're amazing with their damn cell phone. So enough of that. I have with me tonight a fan favorite, a subscriber favorite, and he's actually from Westchester, Professor Mike Geary, a professor at Albertus College of Criminal Justice, Albertus Magnus College of Criminal Justice. And he's a retired NYPD sergeant, law degree, and he's got a lot to say. I'm going to bring him on right now. Mike, welcome to the show tonight.
Hey, Billy. Good evening. Good to see you. Thank you for having me on.
Well, it's always a pleasure, and I know that people appreciate your calm, steady. You know, if it was a heart machine, it would just go beep, 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 beep like that. And with me, it would be like
That's you.
Yeah, it's me. I can't help it with my type A personality, but people like your cool, calm way, and they appreciate it, and I do too. And Mike, you know, we talked about, many people are all upset about, what if this is all the prosecution has, then they don't have a very good case against Kohberger, and they're violating the rights of the defense in this case by not handing this over, not handing that over. Mike, as a retired NYPD sergeant, a criminal justice professor, and of course, a law degree, I'd like to know your feelings on this.
Billy, you know, people seem to have a tremendous amount of imagination when it comes to the Kohberger case. They're thinking up all kinds of stuff, putting it out there, even content creators on YouTube and places like that. And a lot of it is just wild speculation. And you wonder how they even come up with this stuff. But look, this case is a huge, high-profile case. It's probably the most high-profile case that the District Attorney Bill Thompson has ever done and will ever do in his career. Everybody's watching it. People around the United States and even in other places like Europe, they've heard about this case. They're a little bit familiar with it. There is no way that he is not going to follow precisely the letter of Idaho criminal procedure. Whatever the law says, he will do it. He would never, ever take that chance and try to, pull a fast one on the defense. He's got the help with this in this case with the Idaho State Attorney General's office is giving him some extra help with that. 2 extra attorneys to help him because this is such a high-profile case and the evidence they have is so voluminous. So therefore, the people who think that Bill Thompson is out there trying to violate the Constitution of the United States, violate the state's constitution, violate the criminal procedure laws, it's silly. It makes for interesting conversations, but that's about it. It's a lot of people's imaginations running wild. There's no way they are not going to dot every I, cross every T, follow every procedure that they must, because you would never, ever, in this sort of case, want to give the defense any sort of avenue for appeal if and when Kohberger gets convicted.
Mike, especially in a death penalty case, we point out, and people, I guess, don't want to believe us, we point out the fact that they wouldn't be going for the death penalty unless they had the sufficient amount of evidence to do so. And of course, they have to let the prosecution has to let the defense know of their intentions, and they did.
Mm-hmm.
So they're going for the death penalty, which means criminal procedurally, they'll have to pick a jury a little differently when they're going for the death penalty as compared to going for a life imprisonment type sentence, which is surely, in this case, if Brian Kohberger is found guilty, a life without parole sentence, several life without parole sentences, maybe 4 lives without parole.
Mm-hmm.
That sort of makes no sense because you only have 1 life. But sentencing, they can do that.
Yes.
Certainly, he would qualify for that if found guilty after this trial. But they've indicated that they intend to seek the death penalty.
Yeah, it makes sense in this case. You have a state, whether or not, how the viewers feel about the death penalty in general, that's a whole different story. You have about at least 27, 28 states in the United States that have death penalty statutes on the books. The rest don't. But in those that do, this is the kind of case where you will probably seek the death penalty. And even in Idaho, where they do have the death penalty, they don't always seek it in every single case that is what's called a death penalty. A death penalty eligible crime. For instance, if there's two homicides, 2 or more murders, that's a that makes a case death penalty eligible under Idaho law. But they don't always do that. They did a study, I think, in 2021, looking at Idaho state law and the criminal procedure, how they did these cases over the past 20 years. And they usually seek the death penalty in less than 30% of the death penalty eligible cases. The rest, they look to plea bargain, that sort of thing. They charge them with a lesser form of homicide where the penalty is only life, or is life behind bars, and they don't seek the death penalty. But in this case, it was so heinous. You've got it fulfills several different sections of the death penalty statute under Section 19 of the Idaho death penalty. It was especially heinous. It showed a reckless disregard for human life. There was more than one death occurred, so 2 or more. You had 4, and if he was allowed to live, there would be a continuing threat to other people, like in the state, even within the prison walls. So they're looking for the death penalty in this case, because if you're not going to seek the death penalty in this sort of case, why would you, have it on the books? And I think Bill Thompson is smart enough to know that, this is the kind of case where people who are a little bit iffy, or maybe they're just a little bit in favor of the death penalty, they want him to exercise the law, use the power. If you don't use it here, when are you ever going to use it?
Absolutely. I noticed I covered the Eliza Fletcher case out of Memphis, and just recently they've indicated their intention of going for the death penalty in that case. And the district attorney made it clear that he is philosophically against the death penalty.
Sure. But
he will follow the law. And to tell you the truth, I don't care what the district attorney's philosophy is. The law is the law, and you're supposed to follow it, And there's many district attorneys across this nation. Look, Morgenthau, the great Robert Morgenthau of the Manhattan DA's office, was an institution. He wouldn't go for the death penalty because he was against it. The Bronx DA, one time, Governor Pataki, for some case, he removed him because I forget what case it was, but he wouldn't go for the death penalty, and he removed the DA because he felt this was a death penalty case that had to be applied.
Yeah, it's it's not only is it a legal question, it's also for the public, the voting public, the tax-paying public. There's also a little, it's a bit of a philosophical and ethical and moral question. And I'm glad that the DA in that case, Memphis, Tennessee case, actually is willing to say the law is the law. I am a public servant. I will follow it, because quite often you'll see a district attorney. We see this in New York. They won't follow the law. They will substitute their own private morality, their own private political judgment. In cases where, if this ever happened, say 20 years ago, you'd be shocked. You'd say, oh, that would never, ever happen. But we live in very strange times where up is down and down is up. And to see a district attorney say, I might be opposed to the death penalty, but I'm here. I'm the people's elected official, and I will apply the death penalty. I think that's kind of refreshing to see. I'm glad he did it.
Absolutely. Here's the defense has demanded certain evidence. I'm going to play a little Brian Enton to see where they're going with their request, and not just asking, but demanding certain evidence right now.
Yeah, it coincided at almost the exact same time that the hearing was happening. All of a sudden, we're seeing images and pictures of trucks backed up to the front of the house, the front doorway. We had, luckily, multiple photographers here in Idaho. One was helping me here at the courthouse. We sent the other one here and caught that footage of those trucks right up against the door. I asked the University of Idaho about it. Basically, what they told me was that the court has officially turned over this house and the possessions that were inside of it to the families, meaning everything that belonged to the victims inside of that house can now go back to their respective homes. The move out process, Brian, expected to take at least several weeks. And then I also asked about plans for a demolition. They're not budging on that. They said, as of right now, this is only a move out process. There are no plans right now for demolition.
That's interesting because they've said in the past that they did plan to demolish the house, something that makes a lot of the family members of the victims very, very upset, thinking that that house should remain there in case there's a trial and perhaps the jurors want to walk through. So we'll have to see if they decide to leave the house there. But certainly interesting to see the action happening out there today. Alex, take me inside the courtroom, though. I was surprised that the hearing was as short as it was because there were all these motions and
Mike, to me, it's very disturbing that the university intends to tear this house down. And they're going to do it very sneakily, guaranteed. They're going to do it in the middle of the night. They're going to do it when no one's watching, and they're going to knock that house down. And first of all, a little history on the house. The house was donated by the owner to the university, probably for the expressed purpose of knocking it down, because who would ever rent that house again? He could never sell the house to anyone. It has this horrific history, this horrific event that occurred in that house. So what is the rush to knock it down? To me, that house is one of the most important pieces of evidence in this entire case. Why must you knock it down before a potential trial?
Yeah, Billy, strange that the request is coming from the Idaho. I'm sorry, the University of Idaho, and it's not coming from the prosecution. It's not coming from the defense. They are perfectly fine with it, even though there are some in the victims' families that aren't too keen on it. But I think the gentleman who owns the property probably, donated it as a charitable, sort of thing. Maybe got a tax deduction, and now the university does want to move on. But we've talked about this before. It's been since November that these homicides occurred, and it's been almost 9 months. Why can't it just stay there for another 9 months, just in case? I know that the judge is going to allow the demolition to go forward because both the prosecutors and the defense have stated that they have no interest in the house, and the defense has even indicated that defense attorney Ann Taylor even indicated that she wouldn't be interested in the house whatsoever because it has been substantially altered. Floorboarding has been ripped up because there was, probably blood leaking through it. Walls, pieces of wall board and stuff have been removed, and there was a lot of chemicals used in looking for trace evidence. So therefore, kind of making the argument that even if it's still standing at the trial time, having the jury walk through to actually kind of get a feel, like a tactile feel of entering and exiting and going into the bedrooms and just kind of imagining that the house is so altered that it wouldn't even be a really good representation of what the house actually looked like on the night of the homicides. And so I think that the fact that the defense has signed off on a release to say we don't have no problems with it and the prosecution is okay with it, so long as the defense knows that they can't use that as an appealable issue later on, then I think it'd be okay for them to demolish the house. But I'd want to wait. What's another couple of months? Just wait, just in case. You never know. Once it's knocked down, it's over. Just wait another few months.
Absolutely. I think there's nothing like a jury walking through the actual crime scene, whether it's been altered or not for what evidentiary reasons, to remove certain things, cover up the blood, clean the house up. I don't think there's any, look, I've said it ad nauseum on this show that whenever I went to the scene of a homicide, I made it a point to walk through the crime scene and to ask questions of people that had been there prior to me, to explain the crime scene to me. What is this? What is that? All of those things are very important, and there's no other feeling that you can have than actually experiencing the location. So to knock it down, I think is it's not a good look. It's definitely not a good idea. Let me get back to this, Brian Enton.
And we've seen all these filings from the defense saying that the state isn't giving up evidence and discovery, and then the hearing today was somewhat short, it seemed.
Yeah, Brian, I would say it was a bit underwhelming, honestly. We were expecting fireworks, at least a hearing that lasted more than an hour. There were several motions that we were expecting to be addressed, but really, it was whittled down to only about 30 minutes. The majority of the time was the defense asking for more time and more materials that they can review to build the best case possible, talking about the discovery process. What items might the state have that hasn't been turned over yet to the defense? And, you know, to the credit of the defense, they said that we really don't see or believe that there's any wrongdoing on the behalf of the prosecution, and the state backed that up as well. They said, we have everything that you have. There's nothing that we haven't turned over. But as for the stay of the proceedings, that was an emotion that we were expecting to hear about. Also, the grand jury materials that the defense wants turned over, that wasn't even addressed today.
So it's interesting that they were so polite in court, because when you read these filings over the last couple of weeks, it seems like the defense.
Folks, just so you know, this video is a little bit dated. Since this video, the grand jury proceedings have been turned over to the defense, and we've seen a lot of those grand jury proceedings. So, you know, Mike, I just wanted to say, and Brian Hinton's covering it here now, is that chances are that out of the public eye, the defense and the prosecution probably have met numerous times in their respective offices. Probably most likely the defense would go to the prosecutor's office and they discuss certain things. It's not like, you know, they don't have a sword in each other. Each one has a sword in their hand and they're having a duel. They speak. They're all attorneys. They speak. Of course, there's strategy, and they're not going to let the other side know what their strategy is. However, they speak like gentlemen and gentlewomen to each other, and they're all admitted to the bar, and they understand criminal procedure and they understand the law. And you know, I think the press likes to paint this, oh, the prosecution and the defense, they're at each other's. That's really not the case.
Not at all, Billy. You know, they're both veteran. Bill Thompson's veteran prosecutor. He's done many cases. Ann Taylor, I think she was previously a district attorney. She's a veteran defense attorney. They've worked on other cases in the past. They've probably faced each other across the aisle in other cases. You know, they have an ongoing relationship. This isn't the first time they've ever met each other. So there's a lot that's going to be handled out of the public eye, in someone's office, behind closed doors, over a cup of coffee. They're going to talk it over, and except where there's a real important disagreement over some piece of evidence. Other than that, everything's going to be just handled in a normal flow, and they'll go to the judge to settle the dispute that they're having, maybe over a timetable that they can't agree on. But yeah, 99% of the time, everything's handled behind closed doors with people who know they've had a previous relationship. They're working on this case. A lot is at stake for the defendant, but they're going to be facing each other in the future, and they have to. This is part of their relationship, and it's part of what they've done in many other cases before many other judges against different prosecutors and defense attorneys. But yeah, it's all 90% of it's going to be handled behind closed doors. You know, that's it.
Absolutely. Let's finish this up with Brian Enton.
Defense was just furious with the state, basically alleging that they weren't giving over all sorts of stuff. And then in court today, the prosecutor says, wait a minute, you have everything that we have. So it was kind of hard to understand what was really going on.
Yeah, and I think what we're going to see in regards to those other motions that were not even addressed today is some sort of compromise or some solution that happens behind closed doors that we'll never actually know what exactly happened. These are lawyers from both the prosecution and the defense trying to find compromise and doing it where they don't need to be standing in front of a judge. So still TBD whether or not this actually does go to a future hearing, but it's entirely possible we never actually see it play out in the court.
Interesting. All right. Good job today, Alex. I know you have to line.
So that gives us a little bit of a look into what's actually going on, and of course, the press would like us to believe that they're at each other's throats, that they're they're cursing each other out, and that is not the reality of what goes on behind the scenes. Some of the area though that the defense is going right now, and I think we've spoken about this before, and they want to know. They're asking questions about the training. Well, before I get to that, I just want to play a little bit of Shannon Gray, who is the attorney for the Gonsalves. And he gives a little bit of his view on why the house, 1122 King Road, should be preserved. And I'll play a little bit of this. It was also on News Nation.
It seems very commonsensical. What a privilege it is to the University of Idaho to be able to just demo the place and move on. That's not something the victims' families or even the community has the opportunity to do. But they've taken this stance where we want to know what you think, but then we don't really want to listen to what you think if it doesn't agree with our line of what we want to do with the house. So it's beyond me and it's beyond the families, the Gonsalves family in particular, about why they're demoing the house, why they're moving so fast. I think we've expressed, over and over again to them that it's important to just keep the house there just in case someone needs it. And then when the trial's over, do whatever you want with it. And the response has basically been, victims' families spend legal money to give us a legal argument on why we shouldn't have to be able to demo the house, which I find is just absolutely ridiculous.
Yeah, it's interesting that they asked the families what they thought, and even hearing from most of the families that they didn't want the house to be demolished, they're still going forward with it anyway. Can the prosecutors do anything? I mean, obviously the families are in close contact with the prosecution. Can they not step in and say, hey, can you guys just, wait 6 months or so?
Well, I think that's part of the non-dissemination order, right? I'm an attorney that's involved. I can't comment on what I think the prosecutor should do, what I think the defense should do, any of those things, right? So I think the Gonsalves family and it seems that the prosecution and the defense have both released the house. And I think everyone can make their own opinion on that, but I can't comment on it because of the non-dissemination order.
I understand. So, one of the things that's been hard to track, Shannon, is the timeline on the demolition because, they said it was going to happen imminently at one point, which was quite some time ago, and now they're still removing items from the house, but it is still standing. Are they giving the families or you any more specifics on a timeline?
No, not really. I mean, initially it was set to be demolished and then the defense put a stop to it. And then they got a chance to go in and take a look at the house, things like that. And then the private items, the personal items were removed. A lot of the personal items were removed from the home. They were turned over to the families. And then they contacted us and said, hey, if there's any kind of furniture or large items that you might want that are still in the house. And I was contacted by the families and said, hey, Shannon, can you walk the house so we can see if what we want and what we don't want? And basically the university said, no, Mr. Gray, you're not going to be allowed into the house at all. And we'll remove the items and then we'll let you know when you can pick those things up or get those things. And so, and throughout that entire time, from the beginning, we've asked them not to demo the house. So it's been going on for months of asking them. And every time they come back and they give us a date, it gets moved back. So I'm hoping that they'll just stop it.
Well, we saw in Parkland, and granted, it's a different situation. More time has gone by in there, but I mean, to see that some of these families are going to go inside that building, it breaks your heart. But at the same time, you can understand, people want to see where their loved one, had their final moments. Is that a discussion that's come up at all with the Gonzalez's or any of the other families that in terms? I mean, would they eventually want to go inside?
Well, remember in Parkland, though, they know who did it.
Yeah.
They knew who the person was. I think he admitted to it. They arrested him on the scene, and the jury still wanted to go take a look at the property. Right.
Yeah.
This is a case where we don't know anything about the case. We don't have any facts about it. We don't know what's involved in it. And so I think it's emotional for a lot of the families as well. It's the last place where their child was. And I think as part of the healing process as well, is you may not want to step in that house now, but maybe later you might want to take a look and just be where your child was the last time they were alive. And it seems very dramatic, but it's a very emotional, and you also, the families, there's a need to stay connected to the people that were there, Dylan and Bethany, as being their roommates. I think the families feel there's a certain amount of bond there because they were there, right? And you can't explain it as the victims' families. Only the victims can go through that are going through that. But, there's a lot of value to it. I think there's a lot of evidentiary value to it. And then there's also the personal aspect of it for the families. And I would implore that anybody who has any influence on the University of Idaho, who's a graduate or calls them and tells them to stop what they're doing and listen to the victims' families.
Yeah, it's a really, really good point you make, Shannon. And it does seem like it's just so soon that they just sort of want to erase, in a sense, what happened there, almost from like a PR perspective.
Thank you for watching.
Mike, it's amazing to me. And I just think it's so wrong for them to knock this house down before a trial. And I really think it's very political. I think it's all about money. I really do. We could say that we're not on the network television. I think it's all about money, and they want to erase this horrific event from not just the public view, but any future students. I mean, could you imagine, again, how difficult it is to recruit students to go to the University of Idaho post this event? I mean, it's just, if you have a choice of another school that's equal in, say, academic standing and what they offer, I think this event has caused a lot of people. So I can understand from that perspective, the school not wanting it to stand any longer, to erase this horrific. But I think it's so important to this case, to the prosecution of this case, that the house remain there till after the trial. And I think it's more important to the prosecution than the defense. I think the defense probably wouldn't care if the house is knocked down, but I think for the prosecution, it's important to keep that house standing till after the trial's over.
Billy, I agree. I don't think there's any way that the defense would ever want to walk a jury through that house, considering what that crime scene must have looked like in those rooms. And it has all been substantially changed. Furniture moved, things taken out, walls, floorboards ripped up, things like that. I can't see them wanting to do that. The prosecutor, if I'm the prosecutor, Bill Thompson, and even with all the information I have at my fingertips and all the DNA and the cell phone tower stuff and everything I've got, I still want that in my back pocket just in case. And I'm surprised that Bill Thompson would say, we're fine with it. I would think that he would say, he'd be the first one to say, no, under no circumstances, this house should stand on Kings Road, should stand until after the trial is over. Once the trial is over, we have a verdict. That would be the time that I would say, okay, as the prosecutor, it's fine now. We don't need it anymore. But I would always want to have that. I'm shocked that they're just willing to say, hey, no problem, knock it down.
Mike, is it a possibility that the district attorney, Bill Thompson, is being swayed by the politics of the situation and is perhaps even subconsciously, not that he's thinking, I'm part of this community. This University of Idaho is the biggest part of this community, and we want to help them move on from this incident. Is that a possibility?
Well, as I was watching this, the video clip, I was thinking, who's making phone calls? Yeah, there may be some there might be politicians, there might be some wealthy alums who donate money. There might be a lot of political pressure put on Bill Thompson in his office, getting phone calls from people who really want this torn down as much as they want to see justice, and they understand that that place should stand. Their personal feelings about moving on, healing, they want it done now. And he's probably consulted with all the investigators, and he's probably asked them, look, what value do you see in a walkthrough? And he might have consulted also with the attorneys from the state, the extra help he got, saying, look, do you think there'd be any value in a walkthrough? And they might have said, no, you make the final call, but the place is probably so messed up that it's not going to look anything like it looked, that morning when the deaths were discovered, like 9 o'clock that morning. But I'm sure he's feeling a lot of political pressure.
Absolutely. Mike, I'm going to do a quick police off the cuff commercial. Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime from a police perspective, then you're in the right place. And if you're not subscribed to us, go on our YouTube, hit that subscribe button, give us a thumbs up, and ring that bell. If you want to contribute to us, we have a Patreon with 3 different levels. We also have a YouTube channel membership with 5 different levels, and you see the folks in the green font. They're part of our YouTube family, our friends, our subscribers, and we really appreciate them. Mike, one of the things that's sort of come up lately is this whole thing about them wanting to check out the training of the officers involved in that case. And we said earlier on, I think on another show, that we feel that this is like a stretch, that this is almost a Hail Mary pass. And don't let me put words in your mouth if I'm saying that and you weren't the one that said that. But in my mind, it is that let's go after, we compared it to the O.J. Simpson case. Let's go after the folks that did the investigation. Let's find fault in what they did and thus create doubt in this case. Your feelings, Mike?
Billy, no, I agree with you. It is a Hail Mary pass, and I think everybody knows it is, because when you're starting to concentrate, they're doing the best they can. They're zealously advocating for their attorney. God bless them. They're doing what they have to do. They are trying to turn over every single stone they can to find out something that they could use to cast some doubt on the technical abilities, the technical training, the expertise, the experience of some of the investigators. And I think that they're just doing their job. But it is a Hail Mary pass. They're hoping there's something that the detectives are doing or I think there's 3 detectives that they're concentrating on. We don't have the names, but I read that there's 3 detectives that they're concentrating on, no one else, and they want to know those particular detectives' training experience, because perhaps they may have recovered, for instance, like say DNA evidence or something like that. Maybe they were acting as detectives when they weren't trained to do that particular thing. Maybe they were trained in something else. And so they're going after maybe the process of gathering evidence, and then maybe later on they'll look to challenge the actual results of the evidence. But it is absolutely a Hail Mary pass at this point.
Mike, I just want to, before I go to the comments by Truth Seeker, I want to talk about that. But okay. On the NYPD, what you just said, there's a very good reason. They don't allow police officers to make homicide arrests. Mm-hmm. And I always used to like, why not? Why can't they? If they caught the guy, and it's a very good reason. And the reason is because they will get shredded, absolutely shredded on the stand by a defense attorney. And that's the reason the NYPD has the policy. A police officer can be the apprehending officer. He cannot be the arresting officer on a murder case. And for that very reason, which it makes a lot of sense, because if you haven't testified in a homicide case before and you go up there and it's a huge case, a defense attorney is going to eat you alive. And that's my thoughts potentially here. If the catching detective here, and I believe we learned about this early on, I believe he has like 4 years on the job.
That's correct.
And that's going to be scary, because he better be prepped. He better be rehearsed. He better have the district attorney questioning him prior to, if in fact this does go on trial, because if he doesn't, the defense will eat him for breakfast.
Yeah, you've been through it, through the ringer. I've been through the ringer. It's not enjoyable to get ripped up one side and down the other by a defense attorney just doing their job. And this is their job. And I remember riding down an elevator after getting ripped apart, and the defense attorney just wants to talk about the Yankees, and I'm like, I don't want to talk to this person ever again. But he's doing their job, and that's just the way it goes. But I'm thinking that probably they've looked at all the reports, who signed all the reports. Maybe they have some inside information that some of these detectives may be just like, say, a third grade, what we would consider a third grade detective in the NYPD, beginning level detective. They may not have a lot of experience, and yet we see their names on reports that are, a little flag goes up saying, wait a minute, what's his name doing on a report for that sort of thing? Did he actually even get trained to do that sort of thing? That's really good, heads up kind of work by the defense.
Absolutely. Truth Seeker, I'm glad I got back to your comment. I appreciate your comment. They can use a combination of picture and visiting the house to fill in the details. The house does not need to be completely intact. Truth Seeker, that would seem to make sense, and I'll buy into that. However, there's nothing like a human being going into a location that is the crime scene. Believe it, it's eerie, and there is a feeling, yes. There is an aura that you feel in a place where there was a murder in. And believe it or not, I mean, you can call me crazy, whatever, but the feeling is there. There is an aura to that house, and believe me, if they keep it standing and they bring the jury there, the jury will feel it. They will feel what that feels like. And all the pictures, all the schematics, all the house plans, all the laser images won't mean a thing compared to going to that scene.
Bill, you're right. It's a real visceral feeling when you go into a place where that, and you're looking and you see, I don't mean to be graphic, but you see the dried pools of blood, that are decomposing, the stains on the carpeting, the disarray. You see some of these Agatha Christie movies, and the bodies in the library, and it looks like a person's just an actress taking a nap. And death is violent, it's horrific, it's bloody, and it's terrible. And to walk through a crime scene to see and say, okay, I'm walking right past where a body was lying, and that sort of thing, that really hits you. It's not just in between your eyeballs, but it's in all of your senses. And for a prosecutor to have that in their back pocket, I think is great under any circumstances. And walking through a crime scene like that, you'll never forget it the rest of your life.
No, absolutely. Now, they covered it on Cuomo the other night. Why is and I'll play a little bit of this, the defense targeting the police, specifically what we were talking about. And let me play a little of this from Cuomo's show the other night.
The training records of 3 of the police who participated in the investigation that led to his arrest. Why? Well, that's the question. But here's the simple answer, okay? Because you can create the appearance of doubt by looking into who did the investigation and seeing if they are flawed in a way that could have affected their judgment. Let's bring in former FBI agent, News Nation law and justice correspondent Jennifer Coffindaffer, and high-profile defense attorney Mark Geragos. Mark, as a practitioner, what do you do with this kind of information?
You do exactly what they are doing. And it's a little bit infuriating that they're being accused of trying to do something that's untoward. They're doing exactly what a defense lawyer should do.
Which is?
which is challenging the evidence as it comes in. They should be challenging everything as it comes in. They're not the ones who have the duty to prove it beyond a reasonable doubt. The prosecution does.
Now, we remember this, not you, Coffindaffer, you're too young, but in the OJ prosecution, Mark Furman became a household name, especially when defense counsel found evidence of what they argued as prejudice and bias, and that maybe it affected how he did things, and maybe there was sloppiness. How concerning is this for the investigators?
It's not concerning because it's training records. I think what they're going for is to show that these officers aren't well trained and aren't well educated in terms of how they're doing their interviews, how they were conducting their crime scene investigation. But when you look at it, Chris, they are getting training records of people the prosecution isn't even calling on the stand. They're getting training records of individuals who were with other individuals that were looking at the same information. An autopsy, it's the ME that's going to testify about that, not these individuals. Other people who were interviewed, again, they were with multiple people. Those people will be called. So it's not like they have singular information. So it will fall flat, and those records should have been provided anyway.
Well, look, I believe in transparency, so it's good to have it. I have one other quick question for both of you. I don't understand this rush to take down the house. From the university perspective, from the prosecution perspective, and from the defense, right? So first we'll do prosecution, Jennifer. Why? I know the university wants to get it down because they're afraid that it'll affect people's perception of the campus and campus life, et cetera. But why wouldn't the prosecution say, no, we never know if we're going to need it?
It's surprising to me, Chris. That house needs to stay up there. It's so important for these jurors to understand spacing, to understand what you could hear in that house, to look from Dylan Mortensen's eyes as to what she could have seen and how it all played out. I think it's a terrible move.
Yeah, I see that from the defense perspective also, Mark. Like, I'd want it there. I don't know that I'm not going to hear something in testimony where I'm going to be like, wait a minute, what is this woman able to look around corners? You know, look at the angles here. You know, why lose that possibility?
I couldn't agree more. I think it makes no sense to take it down. If I were the defense, I'd be objecting wholeheartedly and full-throatedly. There's no reason in the world that this should be taken down prior to trial.
Hey, thank you.
You know, there's a defense attorney, and I thought more that if the prosecution would want this house. And here's Geragos, a well-known defense attorney, speaking to the fact that if he was on this case and he was the defense, he would want that house up also. And that's interesting. Well, I just want to say another thing. And we spoke about the aura of going to the crime scene. And Coffindaffer actually said something pretty damn pertinent. How about what the witness saw? DM, what she saw, where was she standing? Could she have, what if DM, we find out, can identify Kohberger? What if she says, that's him? I know it's him. But how do you know it's him? Oh, you wore a mask. But how do you know? What if she points and says, I know it's him. I can ID him. What if she says that from the stand? Can you identify the person? Of course, the person on trial is the person that you saw. If she could say that, that's pretty damn powerful. I'm not saying she can. The other thing is walking the crime scene. Let's walk the route that the murderer took. I'm surprised that the defense doesn't want that, because they could use that and say, there's no way he could have killed 4 people in the amount of time taking this route and all the time it took. They could use that to create doubt also. So again, multiple reasons that I do not understand. And I'm looking mostly from the prosecution's point of view, that they will allow that house to be knocked down. I just don't get it.
Yeah, Billy, I agree with you. Mark Geragos and Ms. Coffindaffer both had excellent examples of why you should leave it standing. You don't know exactly how the testimony is going to go, and if, as Mr. Como said, you know, you have DM making an identification, but you go to the house and you look at where she might have been standing and where she claims that figure walked by her. how I want as a defense attorney, if I've got any sort of doubts about that, I want to be able to go there and see, is it true? Could she see? Is there something blocking her view besides just, the fact that it was like, very dark out? Was there any obstructions? What is the sound? What is the sound reverberating inside the house? You want that just in case. You never know. And Mark Argo said, it can cut evidence. No matter who's bringing it into court, can be interpreted in several different ways. Anytime a prosecutor says something is incriminating, is inculpatory, defense attorney who's very bright might say, hold on a second, ladies and gentlemen of the jury, look at it from this point of view. It's actually exculpatory. And so you take that idea and then transplant it to the idea of a house and say, let's walk through it. It's a huge gamble, especially for the defense. But there's no reason for that house to come down before that trial's over. None whatsoever.
And Mike, another thing that is a big deal is, what's the lighting like inside that house?
Mm-hmm.
If you knock it down, you'll never know.
Right.
Will the lights off or will the lights on? Will the lights bright enough for DM Dylan Mortensen, as we know her name to be? Was it light enough for her to make an ID, or was it so dark? Wouldn't the defense want to say the lights were off, or were they on? They were off. And so you're saying you can identify that's important. I think that's very, very important. And again, knocking down a house, they're not going to know anything about lights,
Right.
And a recreation is not going to have the same effect. Deb Jackson Smith, thank you so much for the $2 super sticker. Very much appreciated. So they're not going to know that. So all these reasons we're giving for keeping that house intact, I just cannot understand how they can allow the university to knock that house down and not the defense or the prosecution to object to this. It's baffling to me.
I think it could be, as you hinted before, that there may be a lot of political pressure. We just hope that the university may decide that they'll just hold off on it, because I'm just hoping that they decide to hold off on it and say, look, no matter what we do, this will be known as a homicide scene for the very near, for the foreseeable future. And taking it down now isn't going to change anything 10 years from now. That happens 10 years from now, or people's perceptions over the next 10 years or 5 years or whatever. 6 months is going to go by in the blink of an eye. And if we need to knock it down after the trial's over, we'll do it then. I'm just hoping they have the privilege of doing it. I hope they don't exercise that privilege of knocking down the house.
Yeah, I mean, very baffling. One of the things, of course, we all know now, and we question it, and everyone questions it. And we spoke earlier on the fact that the prosecution is going for the death penalty in the case. And I want to play a little bit from Law and Crime on why there was a death penalty expert and why they're going, and 5 reasons they're going for the death penalty.
It is official. And prosecutors have listed out several reasons or aggravating factors for this. So let me bring back onto Sidebar a very special guest. Some would say a fan favorite, Professor Jules Epstein. Professor Epstein is the Edward D. Allbaum Professor of Law and Director of Advocacy Programs at Temple University Beasley School of Law. He has taught death penalty law nationally to judges and attorneys, and he continues to handle capital cases at the appellate and post-conviction stages. Professor Epstein, a pleasure to have you back here on Sidebar. Thank you so much.
Thank you, and honored to be here.
Okay, you and I had talked about this the last time you were on, but now it is official. They're seeking the death penalty. Were you surprised at this announcement?
I'm not surprised in states that pursue the death penalty that a case like this would get what we call a notice. In other words, a statement of intent. I don't know this particular prosecutor. I don't know his personal values. He's an elected prosecutor in a state that accepts the death penalty, and probably on a scale of terrible murders, and all murders are terrible, this is at the high end.
Yeah, absolutely. It's not only one of the most nationally recognized crimes that we've seen, but I have to imagine in that community in Idaho, one of the worst that they have seen. The reason I asked if you were surprised is because the families of two of the victims, Kaylee Gonsalves and Madison Mogan, they reportedly were supportive of the death penalty against Kohberger. In fact, there was a statement from Gonsalves's family. There is no one more deserving than the defendant in this case. We continue to pray for all the victims' families and appreciate all the support we have received. However, Zana Kernodle's mother opposed the death penalty. So I'm always curious about how prosecutors balance whether or not to go forward with the death penalty if some of the victims' families are in favor of it, but some are not.
So legally, what the victim's family wants is not actually a prosecutor consideration. That's a moral consideration. That's a political consideration. It's a respect for people consideration. But it's not that, gee, it's 2 out of 3, so I must, or it's 1 out of 3, so I must not. That's up to the prosecutor. I am assuming that what happened is this, that one of the families said, we're not in favor, and families can have many reasons for not being in favor, morally, religiously, or just that they've picked up from the news that if this is a death case, it takes longer to get to trial, and there will be years and years and years longer of appeals. So in a let's get this put to bed, there are many motivations to oppose, but I'm assuming that the prosecutor was respectful to all the families, made the decision, and hopefully said to the family that doesn't want it, we respect your decision. We will not put you in a spot where you have to go against your personal values, and I will do everything I can to make this as painless or less painful as I can.
Yeah, I hope that was the message that was communicated as eloquently as you, Professor. The reason I was so excited to have you on, also for the fact that, I just missed you. I liked having you on the last time, but the real reason is they listed 5 different aggravating factors in their notice, in their filing from the prosecutors. And I wanted to make sense of what this means. So I'd like to go over them with you.
Sure.
Number 1, and this is all from the Idaho Code. The first reason they're seeking the death penalty against Brian Kohberger is they say at the time the murder was committed, the defendant also committed another murder. Now, I guess that's not a surprise that somebody who kills multiple people, this is a quadruple homicide, that this is prime for the death penalty. But there are cases, right, where you could kill one person and still get the death penalty, right?
Absolutely. It's just that this is one of a list of possible reasons to take this murder case as opposed to 50 others and say this one could or should get the death penalty. As we go down the other factors, you'll see it doesn't matter if one person died or 12 people died. There, for a single case, X factor could be an aggravating factor. It's just that the Idaho legislature determined if we're going to if we're going to separate out some murder cases that don't deserve the death penalty from some that might, one good way to draw a line is it a single murder or a multiple? And if that were the only possible aggravating factor and you only kill one person, it's terrible, but you're not what we call death eligible. If you kill 2 or 3 at the same time, you are. Now, we're going to learn as we go down the rest of the list. If you kill even one person, but some of these other factors are present, again, you may be what we call death eligible. So it's not they have to prove all of these. They have to prove only one, but they've listed 5 that they feel the evidence supports and that they feel they can fairly present to the jury. And remember, if I'm a prosecutor and I really want the death penalty, the more aggravating factors I can argue to the jury, the more likely some at least will be found.
And bearing some kind of odd change in this story, if this jury finds that he committed one of these murders, they're going to think he committed all of them because it all happened at the same time. There's not multiple killers. It's not spanned at different locations. They're going to think If they find him guilty, they're finding him guilty for all 4 killings. Now, this brings me to the second aggravating factor, which I find really interesting. It says the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. Isn't every murder heinous or cruel and showing a manifesting exceptional depravity?
So this phrasing has been the subject of litigation up to the United States Supreme Court over the last 30 or 40 years, okay? And the Supreme Court held some time ago that terms like that are actually sufficiently precise and sufficiently aggravating. So yes, every murder is terrible. Let me just tell you that Idaho has an attempt to say, what do we mean by those words, okay?
Yeah.
And here's what they say. Those murders where the actual commission of the murder was accompanied by such additional acts as to set it apart from the norm of first-degree murders. You may be scratching your head and say, so what are those? But then they say, if it is...
And what's a normal
right.
murder? I mean, that's something to think
So
about. Yeah.
you jumped ahead. So my point at the end of this is they're doing their best to layer words upon words upon words to give us a useful tool. But at the end of this, your definition of wicked is going to be your personal one. Mine is going to be my personal. It's not like a thermometer that we can say, oh, it's 100 degrees. So here's what they say. Is it extremely wicked or shockingly evil? Is it outrageously wicked and vile? Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. So the last word, cruel, sort of makes sense, right? It's like death by slow torture. That's the added pain. But if I fire one shot into one person's head, to you that might be incredibly wicked and vile. On the other hand, most murders are like that, so I guess it's not so wicked and vile.
You know, this is, to me, this is extremely interesting. Basically, I'm not going to go over every single one of them because he's taken a long time to get through all of them, but the aggravating factors that raise it to a murder first degree, which makes him death penalty eligible. And they talked about the heinousness of the crime, the fact that it was multiple victims. And I think they would have gotten to it that it was in the commission of another felony. And I believe that's why they also charged burglary, so they could hang their hat on that. And I know in New York State, one of the requirements also to be charged with murder, one, you have to be over 18. I don't know if that's in the Idaho law. I know that's in the New York law. And I don't know what the fifth one is. Do you know what the fifth one is, Mike?
Yeah, let's see. Burglary, more than one person, especially heinous. Also, the reckless disregard for life. And I think the previous, from my notes, I have that he represents a continuing threat to society. So it's not like that he would kill again if he was ever left in the general public or left to live, like, for instance, behind bars, that he's the kind of person who would kill again.
Absolutely. I want to go to a quick commercial. Folks, if you're looking for a great attorney in the New York metropolitan area, then Joe Murray is your man. Joe's a retired NYPD police officer and a fantastic defense attorney. You can reach Joe on his cell at 718-514-3855. You can email him at joe@jmurray-law.com. Go on his website, jmurray-law.com. As I said, Joe's a fantastic defense attorney and also a huge supporter of the Police Off the Cuff podcast. He's been with us from the very beginning, and we appreciate all of his advice, his recommendations, and, of course, his support to this channel. You know, Mike, I think, as much as all the coverage on this case, there's always things that are new and that we don't know and other people don't know, and people bring things to our attention. I mean, I know one of the things out there is there's a petition, an online petition to the University of Idaho that they not knock the house down. Whether that has any effect whatsoever on the decision remains to be seen. But there's a lot of emotion in this. There's a lot of emotion on both sides of this case. Folks that believe that Brian Kohberger is innocent. Again, I'll always say that he has the presumption of innocence. He's innocent until proven guilty. But I also want to always remember and always mention that, and we forget maybe to say this, that this case really is about these four individuals: Ethan Chapin, Zainer Knodel, Madison Mogan, and Kaylee Gonsalves. And they lost their lives in this incident, and we can never, ever lose sight of that and forget that, because again, that's exactly what this case, and we can get involved in the legalese, we can get involved in the law about what it means. And, these incidents happen in this case in 8 or 9 minutes, and it'll go on for years determining guilt or innocence. And I just want to point that out, that we never, ever lose sight of these four kids that lost their lives on November 13th, 2022.
Yeah, Billy, this is a case like from our perspective, we're police officers. This is police off the cuff. We see this from the side of the police, the side of detectives, the side of the prosecutor, and therefore we understand from our police work what homicides look like, people's behavior patterns before and after, and some of the suspicious things that people do that raise a flag in the back of your mind and say, oh my, there's something up with this person. This person is acting like an innocent person would. This person is acting with consciousness of guilt. We don't take the theoretical approach. We're not theoreticians. We don't decide how many angels can dance on the head of a pin. We're worried, and we're steeped and trained and have the experience in how crime is actually committed. How do you go about solving the crime? People have can look at this from a philosophical point of view or from a realistic police point of view, and everybody can differ on how they see things. But no one should ever forget this is a heinous crime, and that there is at least some measure of evidence that points to one particular individual, and that although he has enjoys the presumption of innocence, and it is up to the prosecutor to prove his guilt beyond a reasonable doubt, and he's going to be judged by a jury of his peers. Your case doesn't go this far without there being a tremendous amount of evidence that actually is incriminating evidence, and the police or the prosecutor, they're not just making it up out of thin air. There's no, oh my goodness, a big misunderstanding. If there was a big misunderstanding, we would have had, the alibi defense already. He's way behind. He's like a month behind his deadline for turning over to the prosecutor his defense of alibi, names and addresses and phone numbers of witnesses he's planning to call that would vouch for him for his whereabouts on the night of the homicides. We haven't seen that, so let's use our common sense here.
Mike, very well said by the lips of a professor and a lawyer and retired NYPD sergeant. And this case will take into consideration, and I always like to say this, the art and the science of investigation. And the science in this case could very well be the most powerful evidence that we'll see in this case, whether it's the digital evidence that will show, we saw it come, how important the digital evidence was in the Murdoch case. We're going to see the same thing here. And in this case, we also have DNA. Yeah, it's touch DNA. And we have the science of investigative genetic genealogy, which was able to identify this DNA. We had probable cause established through CODIS and the father's DNA, which I believe they also used investigative genetic genealogy in building a family tree. So the science of investigation will definitely come into play with this. And look, as new things come forth in this case, we'll be reporting it to you. Right now, because there's a lot of legal maneuvers behind the scenes that we may not be privy to, the information just comes pouring out of the bottle like molasses, very slow, you know. And we're doing our best to report it to you as it happens. Mike, your final words.
Yeah, I think, like I always say, patience for everyone. You know, your subscribers and your viewers should not sit there and think that, and just go the philosophical route, like, oh my goodness, you know, this is he's probably totally innocent. This is a setup. You know, the cops are just they don't know what they're doing. They don't know what they're doing. They picked his name out of at random, and they're just, you know, driving this case forward without any sort of evidence. No, don't think that way. Take the common sense way and say, you know, listen to us. We have the experience, and you know, listen to the people who've got the experience. That's the best way to judge this case.
100%. Folks, I want to thank you all for coming by on a Sunday night and listening to our take on this case. We appreciate all you guys, our subscribers, our friends, and our fans. And again, thank you for coming by on this Sunday night. Mike, have a great night. And
Thank you,
I'll
Billy.
See you soon.
Good night, everyone.
One episode just ain't enough.